Good afternoon, everyone, and welcome to this, the latest in the series of Herbert Smith Freehills webinars. We're here this afternoon to talk about employment-related issues in the context of multi-jurisdictional business transfers. I'm joined here today, and pleased to say that I'm joined here today by Christine Young, a senior associate in our employment group based here in London, Emma Röhsler of Counsel, based in our Paris office, and my fellow partner, Andrew Taggart, a partner in our employment group. My name is Mark Bardell. I'm a partner in the International Corporate Division based here in London. Before we get started, a couple of administrative points. First of all, we would encourage you all to ask questions of our panellists here today, and there's a facility on the screen in front of you to ask a question. I will read those and pose those to our panellists towards the end of the session. And we'll break up today's 1 hour webinar with approximately 45 minutes worth of speaking from me and hopefully more from the panellists, with 15 minutes left at the end for questions from you. We'll answer as many questions as we possibly can. Those that remain unanswered we'll hopefully address by email afterwards. For those of you who wish to collect CPD points from this afternoon's webinar, again, there is a click-through button on the screen in front of you to enable you to do so. Well, without further ado, I'll hand over to my partner, Andrew Taggart, to give us an overview of what we're talking about this afternoon.
Thanks very much, Mark. What we're going to do for the next 45 minutes is try and emphasise the importance of employment considerations to the timing of a deal where you're looking at a multi-jurisdictional sale or acquisition. And we'll look at some of the things that can go wrong. So if you don't plan it properly from an employment perspective, there are additional costs. There may be civil as well as criminal penalties. And the timing goes all wrong. So we'll come on to a couple of anecdotes of where this has gone wrong in different jurisdictions. But the key thing is managing the expectations of the deal team. So from an employment department perspective, we want to make sure that the corporate department is happy with what we're doing and ultimately that the client gets the deal over the line at the right time. So how we're going to do this is in terms of phases. So in a typical deal, there'll be various phases. So there'll be a planning stage, a due diligence stage, negotiating the SPA stage, and we'll look at those from a multi-jurisdictional perspective. So, Mark, I know you're going to guide us through, from a corporate perspective, how you see deals working, and then we will respond to your points.
Sure. Well, what better place to start in that case than the beginning? What are your thoughts as to planning the transaction? What are the key issues from an employment perspective?
Well, I think the starting point is, as Andrew mentioned, working out what needs to be sold in each jurisdiction, and the aim being to sell all of the businesses at the same time and within the timetable envisaged. And from the employment side, there are a few things that we need to think about at the outset to make sure that we achieve that objective. The first of those is around information and consultation. There are a number of jurisdictions where there's an obligation to inform and consult, either trade unions or works councils,
Sure.
Or across Europe there may be a European Works Council as well. Some of those jurisdictions there's a pre-signing obligation. So, for example, in France and the Netherlands, and in some jurisdictions like Italy, there's a post-signing but pre-closing obligation. So that's one of the issues. There are other jurisdictions where there are no requirements to inform and consult at all. So that has a different metric to it. So, for example, much of Asia, Brazil, Chile, Colombia, South Africa, for example, even where there's an automatic transfer principle, so even where the employment transfers automatically, there might not be an information and consultation obligation. Also, the processes are different in each jurisdiction, so you need to factor that in. And then the question about, well, how long is it going to take? That very much depends on what is envisaged in respect of the employees. Are there any plans to change terms and conditions? Are there any plans to make redundancies? If there's anything that's potentially seen as detrimental to the employees, that's very likely to elongate the process because the information consultation process is going to take longer. So the key takeaway really is to make sure that we've managed the expectations of the clients and the deal team at the outset as to how long these processes could take and factor that into the timetable accordingly.
Of course.
And just to add to that, the difficulties obviously arise in those jurisdictions where information on consultation has to take place in advance of signing, because that's where the real impact on the timetable could arise. The obvious usual suspects are France and the Netherlands. In terms of the Netherlands, the Works Council will need to be informed and consulted in good time in advance. And it's difficult to understand exactly what's meant by that. It would depend on all the circumstances and the relationship with the Works Council. It may also be necessary to check the terms of any collective agreements in force in the Netherlands, which could impact on timing. So it's something to bear in mind. In France, recent changes to the law have meant that the visibility on the timetable has improved significantly. So it's now possible either to enter into a collective agreement with the Works Council setting out the timing, or to have maximum time periods after which the opinion from the Works Council is deemed to have been given. And that ranges from 1 month to 4 months, depending on the circumstances. 1 month just with the Works Council, 2 months if an expert's appointed, etc. So whereas previously in France there was a great deal of uncertainty as to when the opinion would be given and the signing could take place, now there is in place, or will be, hopefully by the end of the month when the application degree is in force, more certainty on that. And even in Germany, there's an obligation to provide information, but on occasions it can also be necessary where there are operational changes involved to negotiate a balance of interest plan or a social plan. So it's really important, especially in the European jurisdictions, to look at what obligations might be triggered.
Of course. And of course we must not lose sight of the fact that fundamentally, in terms of the timing of all these obligations to consult, or indeed a lack of obligation to consult, any buyer is going to want to make sure that it keeps good relations with those employees. Andrew, do you have thoughts as to the best timing to do that in order to make that work?
Yeah, this issue sometimes comes up where there's price sensitivity. So if the target or the buyer is listed in some way, and price sensitivity issues. Traditionally, it used to be the approach of, oh, well, if it was an English-based transaction, then you'd arrange to speak to the appropriate representatives just before you announce the signing. But clearly that doesn't work if you've got French or Netherlands companies involved, because those jurisdictions, as Christine and Emma have just explained, have pre-signing requirements. So you may find yourself in all sorts of bother if you decide to adopt an English-only approach where there aren't usually pre-signing obligations. And you may say, well, what would actually happen if you did try to go ahead without going through the necessary requirements? Well, a good example of that was the GDF and Suez transaction, where at the end of 2006 the European Works Council for Gaz de France did actually make a High Court application in France to stop a deal going ahead because there hadn't been the appropriate information and consultation before the signing, and that resulted in quite a lengthy delay to the transaction, an increased cost and embarrassment, in fact, for the transaction team. So there are real teeth to these sorts of regulations.
Of course, and a point that any prospective party to a transaction would do well to bear in mind. One thing that strikes me about the points that you're making there is the importance of any party to a transaction not to impose its home jurisdiction view on the rest of the world. One thing I remember vividly was participating in a conference in mainland China to hear a prospective purchaser talk how afraid they were of overly protective regimes in continental Europe for the benefit of employees. A surprising comment to me to hear from mainland China to be making about continental Europe, which showed to me how important it was not to bring to bear my home jurisdiction view of the world and impose it on others. Again, any thoughts to share with the audience on that?
I think that's really important. Sometimes, particularly the European jurisdictions, can have a bit of a bad reputation in terms of operating and transactions. But of course, deals do get done, and there are obviously ways of managing the obligations that you have. There's no way of avoiding an information and consultation obligation where it's in place. But what you can do is think about structuring your transactions so you don't trigger necessarily the obligation earlier than you need to or you want to. And we use a number of mechanisms which can help in this regard. one of which is the irrevocable offer structure, which is a very seller-friendly mechanism whereby the buyer makes an irrevocable offer to the seller fixed for a certain period of time. The buyer is bound to buy, but the seller is not yet bound to sell at that point in time. And so the seller hasn't got an obligation to inform and consult with its works counsel. So that can be a solution for the seller. Obviously, it doesn't help the buyer if the buyer has in place a works counsel that needs to be consulted. Another way of dealing with this potential difficulty in the European jurisdictions in particular is a framework agreement, where a number of countries are involved in the transaction. If it's possible to have staggered sale and purchase dates or signing and closing dates, it may be possible to have an overall agreement for the sale of the business globally, and with the more difficult jurisdictions dealt with in schedules, whereby the deal principles are set, but the detail of the transaction in particular locations are not finalised. And that allows an overall deal to take place, whereas in certain jurisdictions it may happen later once information and consultation has taken place. But that will obviously depend on what's possible commercially, the client's requirements, but there are obviously ways of dealing with this.
And one of the points to bear in mind is across your jurisdictions at the outset, is to making sure that your local counsel have signed off on the structure for the deal. And there's a cautionary tale that we're aware of from Mexico where there's a court case that's still ongoing, and it started 5 years ago. Started in respect of one individual employee and their employment situation, and it has resulted in the court assessing the validity of the transfer of the employees. And clearly that's the last thing that you want on a deal, so definitely worth at the outset making sure that your local counsel are happy with the structure.
Well, that prompts me to think at the core of the deal team, beyond planning, beyond structuring, you then move on to diligence. And again, I'd be interested to know your top tips, as it were, for diligence and employment-related issues there.
Certainly. Well, as we've just been talking about works councils and consultation obligations, obviously the first thing to work out is what there is and where, which will help with the deal timetable and the planning. There are, as Christine mentioned, automatic transfer provisions in much of Europe, and no automatic transfer of employee provisions in other countries such as Australia, New Zealand, Hong Kong, India, Indonesia. But in those countries, even where there are not automatic transfer provisions for employees, there may be other documents that you need to review and verify because they'll impact on the deal as well. For example, in India, a collective bargaining agreement could set up an obligation to inform and consult. In Japan, a labour union agreement might be in place which would create an information and consultation obligation. So yes, it's not just the typical jurisdictions that need to be verified, and that should come out in a good due diligence process. Other things to be aware of are obviously change of control provisions in certain of the executive contracts. And also look at the difficulty of replicating terms and conditions if the seller has in place a group bonus scheme or a stock option plan, which may not be easy or possible even to replicate for the buyer. That could cause issues with the employees, which will mean that it's important to know about that in advance and plan for it.
There are other, we've got an example from Australia which is, again, it's a cautionary tale really, about making sure you know exactly what the terms and conditions say at the time, and also what might be triggered as a result of the deal. There's a case that went all the way to the highest court in Australia around whether or not employees who were being cherry-picked, because Australia isn't an automatic transfer country, and the buyer was cherry-picking those people and assumed that they wouldn't need to make redundancy payments because they were being offered the same job on the same terms and conditions. Yes. And it turned out that there was the potential for redundancy payments to be made. Now, the highest court ultimately decided that on the wording of the policy, they weren't paid out in that situation. But it's the type of thing that you don't want a huge redundancy liability coming out at the last minute in the deal. So just a reminder on what to look out for.
Of course. And we focused there on discussing employment-related issues and liabilities in particular. What about other related matters? pensions. Anything to say on that?
It's a really good point, Mark. I mean, it's often employment lawyers think, well, should I just be looking at the employment bits? But there are related liabilities. So pensions is a good example. Important at the earliest stage to try and work out what sort of pension liabilities they are. Are they defined benefit arrangements, which are often complicated and expensive, or are they just defined contribution arrangements? And it's important not to jump to conclusions or make assumptions. Often you might think, well, most European jurisdictions just have a state scheme, and that's relatively easy for a buyer. It just has to continue paying into the state scheme post-transaction. But that's not necessarily the case. We are finding more and more now that senior executives might be given a top-up arrangement or some sort of guarantee that isn't necessarily been funded, and so you might, as a buyer, suddenly find that you have to pick up that liability when senior individuals actually do retire. So it's important to look at that. Also, you may find that redundancy schemes have a pensions element to them, and those who are well versed in the transfer of undertakings regulations in the UK will know about the Beckman and Martin decisions, which look at whether early retirement rights can transfer over to a buyer, whereas normally occupational pension rights do not transfer. It's important to dig down a bit at the due diligence stage and make sure that you're covered in terms of looking at, does pensions overlap with employment for those sorts of benefits, which can be very expensive. Looking on a more international basis, one situation that's come up is in Japan. There seems to be a practice that where individuals retire, they don't just get a pension, they may also get a one-off severance payment. So another issue to look out for, and also look out to see whether the pension benefits, for example, in Japan, are funded properly. If they're underfunded, it may be, so there's no automatic transfer principle. If you take on the employees, you may be taking on the underfunding liability as well. Yeah. Emma mentions, what about stock plans and bonus arrangements? So incentives is another important point. So it's important to be joined up with your pensions and incentives colleagues and to find out at an early stage, well, what sort of arrangements are in place in the seller's organisation that you are going to have to try, if not replicate, then produce something of a substantial equivalence for the post-transaction period.
Yes. What other practical considerations are there at these early stages of a transaction?
The key is really proper preparation, especially where you're working across jurisdictions. There's so much to do. How do you sort of focus your attention? And I suppose the first thing Emma mentioned before, looking at each jurisdiction. How many people are in that jurisdiction? How many employees? What are the obligations there? And when do they need to be undertaken? And is this going to be a jurisdiction we think could be problematic? The one practical way we deal with it is put together something called a traffic light table. So we identify the jurisdictions that will be applying in a deal, and we allocate them a colour, green, amber or red. So green countries are often countries where there's no obligations to undertake information and consultation. So Hong Kong, Turkey, those kind of countries.
Sure.
Amber would be where there's an information and consultation obligation, but it might be only just a civil penalty, so a civil fine, if you don't comply with that. So, for example, the UK and India and Singapore. And then you've got red countries where you're obviously going to spend a lot of your time focusing on, such as France, Netherlands, and potentially Germany, where there are either criminal sanctions if you don't comply, or they can stop the deal going ahead. So obviously that's when you focus your attention on those countries. The other thing to bear in mind at the start is the paperwork that will need to be done. With an information and consultation process, there's obviously various documents that need to be prepared, and they are different depending on the jurisdictions. But it's good to get a head start and make sure that those documents are consistent across the countries and what's being said. And in those countries where there isn't an information and consultation process, where you're hiring the employees, then you need to start thinking about what employment contracts are going to be put in place. There's another thing to think about, that there are some oddities in some jurisdictions where you may not be transferring all the employees. So, for example, in Singapore, managerial or executive positions won't transfer automatically. So you may end up having a bit of a hybrid situation where you're transferring some and then having to work out how to deal with others. So it's just having those in mind at the outset.
Sure.
For example, just to add to that, exactly as Christine was just saying, for France, to transfer protected employees in a partial transfer of business will require the authorization of the labour inspector. So that will need to be factored in, otherwise the seller and the buyer will have the odd situation of most of the employees transferring across on a certain date, the transfer date, and the protected employees tagging along a few days later once the authorization is obtained. So that's a practical consideration. It's also important in some jurisdictions to make sure that the buyer, in fact, has a viable business plan for the business it's acquiring. In France, for example, in a case involving Samsonite, which sold its luggage business to a company called Energy Plast. Energy Plast had a business plan to make luggage and solar panels, as you do together. In fact, that was held not to be a viable business plan, and after a year, Energy Plus went into liquidation, resulting in 205 redundancies. And in fact, the employees brought a claim against Samsonite for failing to verify that the entity to which they transferred their business was viable as a business, resulting in 2 years' damages for each of the employees paid by Samsonite. So even when the sale is over, the seller is not necessarily out of the clear.
Yeah, of course. A very important point for any would-be seller to bear in mind. But what about the commercial situation where the intention is not to transfer all the employees of the business? I'm thinking of those examples such as, in my experience, a bid for Allied Domecq by Pernod Ricard and Fortune Brands in the US. And the plan was there to break up that business into its component brands and take the various employees who were all pooled across the brands and apportion them to those different business units. What about that commercial situation?
Sure, that comes up quite a lot, obviously with people acquiring parts of businesses rather than the whole thing. And from the employment side, the key question is about assignment of employees. Who's actually assigned to the business that's transferring? And is the current assignment sufficient? What you don't want is not having sufficient people to service the business once it's been split up. One practical way that's to deal with this issue is something called bundling. So imagine you've got 9 employees, none of whom are wholly or mainly assigned to any of 3 business units. But the 3 business units need approximately 3 people each to service that business. So what you can do is reassign all of them so that each person is 100% assigned to one of the business units. So you end up with 3 people assigned to each of the businesses, which can work on a practical level. You just have to bear in mind that there may be consultation obligations
Sure.
and before you go ahead with that assignment, and you may also need to get employee consent.
Sure. And then I think we've now covered those initial stages of planning and diligence. Moving forward in the life of a transaction to signing the SPA, what practical issues can we bear in mind there? Emma, you mentioned earlier the idea of irrevocable offers in the deal structure. Thinking of terms for the sale and purchase agreement or the like, what can you say there?
I think another useful thing to bear in mind for the SPA itself, the transaction document, is to set out exactly who's paying for what. Because sometimes local legislation will provide for that, other times it won't be so clear. And it's obviously better for the buyer and the seller to set out expressly in the SPA what each of their liabilities are. For example, sometimes the buyer will compensate the seller for certain payments, or the seller will pay for sums which are due to be paid to the employees after the transfer date, but which relate to the period prior to transfer. And it's always best to have that expressly set out in the agreement. In addition, because there may be information and consultation obligations, it's useful to have a cooperation agreement. So the purchaser or the buyer will provide reasonable information to the seller reasonably promptly to allow that process to take place. Also, it's useful if there's a period between signing and closing to make sure that there are carefully drafted conduct of business provisions, so the buyer isn't inheriting liabilities it's not expecting, which arise in the period between signing and closing. And obviously all of that's in addition to the usual warranties and indemnities to protect the buyer on the acquisition of the business.
Sure.
One situation that arose recently in Germany has a different arrangement on objection. So employees who are transferring automatically from the seller to the buyer have a right to object, and normally the effective objection is that you're treated as having resigned with effect from the date of the transaction completing. But that's not the case in Germany. If employees in Germany object to transfer to the buyer, then they remain employed by the seller, and if the seller wants to not have those employees anymore, then it needs to make them redundant, and that has an obvious cost. So if you're acting for a seller and employees object, you might want the buyer to pick up the cost of doing that. So other quirks to look for and need to be put in the SPA. As Emma says, it's important that the SPA picks up where all the liability should be apportioned.
Of course. And we focus there on the sale and purchase agreement as the primary transaction document. But what about other documents? Certainly, in my experience of late, the transitional services agreements and related issues become as much as a problem as the main transaction document itself. What are your thoughts on that?
I think that's absolutely right, and it's often something that's left quite late in the day. Everyone's focusing on the main sale and purchase agreement, and from the employment perspective, who's transferring and have we done all the information and consultation in respect of those people?
Yes.
But actually, there may be employment issues in the transitional services agreement. For example, once these people transfer over with the sale and purchase agreement, are you actually going to have sufficient people there to service the transitional services arrangements? And then what's going to happen to those people when that agreement ends? And factoring that in and making sure there's relevant provisions in the transitional services agreement to deal with that, rather than what often happens, it gets left to the last minute and it's not something that you want to leave to the last minute.
Yes, and I think we've all had experience of that. Moving on then, beyond signing, thinking about closing and even post-closing matters. What practical tips can we offer our audience there?
Well, we've talked before about the information and consultation, but we shouldn't forget about the countries where there isn't an automatic transfer process, and there can be issues there as well. So, for example, in Japan, we're aware of a case where in that case there's no automatic transfer. So the purchaser or the buyer cherry-picked the people that they wanted to offer employment to. And the employees that were left behind weren't very happy about it not being selected, and weren't very happy about the severance arrangements that the seller was offering. So they got themselves organised and got themselves a union, and that union alleged that there had been criminal conduct in respect of the seller to do with not paying overtime payments. Yes. And that was used as leverage to get the seller to renegotiate with the buyer. It resulted in the deal being delayed, and ultimately resulted in the buyer taking on more people, and the seller's employees who weren't taken on getting a much higher severance payment. So people power can be quite important in some of the other jurisdictions as well. In China, for example, the local authority needs to sign off on employee settlement plans before the deal will go through. So we've been focusing on employee representatives and employees, but actually there's third-party local authorities that can be involved too, and we shouldn't forget about those. Also, from a general perspective, whether it's an automatic transfer country or not, there's practical points around making sure that everyone's fully briefed in all of the jurisdictions as to what's happening, making sure that there's consistent messaging, because we often find that employees in other countries will speak to each other and find out if the same thing is being said to them in the different jurisdictions, and making sure that you have translated documents if you need to translate them. So, for example, Russia, Canada, France, you would need to get some translations of the documents, and making sure that that's done in time. And also thinking about crisis planning. So thinking ahead, do you think there's going to be an industrial relations issue in a particular country, and trying to work out ahead of time what can you do to achieve, to stop that from happening, which may be the case of sending some quite senior people to meet, for example, if it's a union or a works council, to meet them so that the employee reps think that they're being taken, their points are being taken into consideration. Sure. Now that can be a good thing and a bad thing if you send senior people over to negotiate, but it's one thing to bear in mind.
And what are those risks that we ought to think about when senior people are sent over to negotiate?
I think one thing, as Christine just said, understanding the cultural differences in different countries, and if senior people from another location are being sent, just to make sure that they're briefed and they're aware of how the negotiations might go, what might happen. We have, for example, an incident where one of our Asian clients went to participate in information and consultation with the French Works Council, and we briefed them in advance about the possibility of something we call bus napping, which is essentially where, for a couple of hours, the Works Council might lock the door to the meeting room, not allow them out. And despite being briefed, the client was a little bit surprised that, for example, they weren't allowed lunch, that they were not permitted to leave the building. And it can be quite intimidating. So the more preparation, the more cultural understanding, the better. And obviously, much better if you can get the local HR team involved as well, if it's possible commercially, because they will really understand the local pressures, the customs, that these things are not necessarily the end of the world. They do happen. It's quite common. And it may be part of the negotiations.
Yes.
And another example from another country, where, in this case Italy, where it is important to make sure you tell the employee reps everything that they should be told, because it can come back to bite you. And there's a case we're aware of in Italy where they started off as an intra-group transfer, and then they sold the purchaser effectively, so that it turned into a series of transactions that resulted in a third-party acquisition. But they didn't tell the employee reps about the second stage, so they thought it was an intra-group transfer. And when they found out, they went to court and claimed it was anti-union behaviour. And the court agreed with them. And the normal sanction would be to stop the sale going ahead. But because of the timing, the deal had already been done. The transfer had already happened. So actually, in that case, there wasn't a lot that the court could do. But it is a bit of a cautionary tale. Make sure that you do tell your representatives the whole story about, particularly if it's a series of deals.
Yeah, of course. And again, it gets back to this point of not imposing, I think, your home jurisdiction view on others. That structure of a series of transactions or hive down, I think is referred to in the States as, in some places, as the Texan two-step. And imposing that sort of dance rigour on the rest of the world may just not go down all that well. But related to that, the idea of a series of transactions, what about the thought often posed by a series of buyers as to whether there can be pre-transfer redundancies so that the seller has to sort that issue out? What about that idea?
You're absolutely right, Mark. It's one of the factors that comes up in many transactions. Often the rationale for an acquisition will be, well, we think we can run this business more effectively if we can reduce the headcount cost. So you often get, if you're acting for a seller, a request from the buyer to do the buyer's dirty work for it and make redundancies in the pre-transfer or pre-completion period. And the general advice there across the jurisdictions is you need to be very careful doing that. You shouldn't just be saying, well, that's fine, we will take on that kind of responsibility. In particular, the closer you are to the actual transfer, the more risky it is, and there's specific legislation in most of the jurisdictions. For example, in some of the European Union jurisdictions, dismissals, if they're by reason of the transfer, will just be ineffective. And France and Germany are examples of those. So you think you've made these employees redundant in connection with the transfer, but they're not. They're still employed, and you've still got to pay their ongoing employment costs and go through a redundancy process later on. In other jurisdictions, they're automatically unfair, and examples of that are in the UK and in South Africa and in Mexico. But in many of the others, there aren't any express provisions, but employees will still be able to bring, for example, unfair dismissal claims. And there are a couple of quirks to watch out for. For example, in Brazil and Chile, you may need to get some local authority approval to dismiss certain categories of employees, for example, those who are on maternity leave or pregnant, or who have union official duties. So it's so you should be cautious in agreeing if you're a seller to do the buyer's redundancies for it. And it's important to manage the management expectation. We're doing a transaction at the moment where the cost, the headcount cost, is such a crucial feature, and because it takes a long time in France to undertake redundancies, you can't just do them immediately before or immediately after the acquisition. That this may mean the deal doesn't go ahead, and it was something we pointed out to the buyer, would-be buyer at an early stage. So don't leave it to the last minute, and don't expect that you'll be able to go ahead with this without some problems. Obviously, it impacts on the deal timetable. One of the often quoted examples for redundancies is when Marks and Spencer's decided in 2001 to close its stores in mainland Europe. It resulted in some protests by union and staff, and there were potential criminal sanctions against a UK-based director, and the process was slowed down quite an amount. So again, look at the timetable and manage the expectation of the client that it's not something that can be done immediately. Also, depending on the number of employees who are proposed to be made redundant, there may be collective consultation obligations. So that would mean involving works councils or trade unions, or in some cases European works councils.
Sure. Another thing that is often asked about is harmonisation of terms and conditions, so that the buyer wants to move the employees onto its terms. Do we have any thoughts that we can share with the audience on that?
I think the distinction here is between where there is and there is not an automatic transfer regime. So where there is no automatic transfer regime, you can broadly pick the employees you want to transfer over and leave the ones you don't behind. So and then you can hire them on the terms that you want to. So you'll say, well, these are the 50 employees that I want to take on, and these are the terms that I want to offer them. But one word of caution in Australia is that if you do that kind of thing, it may well be that continuity of service will be preserved. So continuity of service won't end as at the date on which they're dismissed from the seller and taken on by the buyer. It will be preserved. Usually the transferor will want to transfer, the buyer will want to know exactly what terms the employees are being taken on, and in terms again of management expectation, you should tell the buyer, if that's who you're acting for, that being able to impose new terms on employees is often pretty difficult, especially where there's in particular where there's an automatic transfer regime, which obviously operates across the European Union. Unusually, the UK is the most difficult jurisdiction to deal with here, and usually the UK is a softer touch as far as employees are concerned. But here, if you are making changes to terms and conditions and the reason for the changes, the transfer, or reasons connected with the transfer, then the changes will be ineffective. They'll just be void, even if the employees have agreed to them. Now, there are some changes to the legislation in the UK that are coming up and expected to come into force in the new year to bring it more into line with the rest of mainland Europe. But at the moment, if you're making changes because of the transfer or a reason connected with it, then those changes will be void. And the same position is the case in the Netherlands. But other European jurisdictions, Spain, for example, Germany, provided the employees or the unions or works councils agree to the changes, then you can make them, even if they are connected with the transfer itself. Mexico and South Africa have a quirk to it that it can be done unilaterally, so you don't need agreement from the employees, but only on the proviso that the terms are no less favourable to the employees concerned.
Just to add to that, sometimes in some jurisdictions there can be a bit of a honeymoon period as well. In France, for example, there's a period of 15 months where the transferring employees can cherry-pick their previous terms or the new employer's terms and have the best of both worlds. So sometimes that will delay complete harmonisation.
Sure. And I think in UK context, I think there are sometimes issues about abilities to change terms and conditions, and a couple of times that's popped up. Andrew, do you have any thoughts on that?
Yeah, that's right. I mean, sometimes if you're trying to change terms and conditions in the UK, if it's a small number of employees, one get-around has been, it's a rather extreme get-around, but you dismiss the workforce and re-engage it on changed terms. But that is a very convoluted and real last resort situation. Otherwise, you're trying to come up with one of the exceptions in the legislation is the economic, technical or organisational reason, entailing changes in the workforce, to give it its full definition. What does that mean? Well, one of the classic examples is where there's a redundancy, so you just need fewer people to do the work, or you're introducing some technology, which means that fewer employees are needed, and changes in the workforce means a change in the number of employees or a change in their role or function. So it may be that you're able to make some changes for one of those reasons.
Sure. Well, look, we've rattled through then a transaction, if you like, from planning through diligence to signing and then on to closing, completion, and some of those follow-on matters. A couple of the themes that have stuck out for me are certainly the importance of preparation and planning. And the other, I think, is experience. To have somebody who's experienced in dealing with the issues across jurisdictions and who's able to compare experience in one jurisdiction with experience in another to anticipate problems and the rest of it. What would you say are our top tips from our experience of doing these kinds of transactions?
I think that you have to ask the client, if you're acting for a buyer or seller, what's its deadline? When does it want to have all the different businesses sold? Is there an absolute must-do date? And then work backwards from that and explain to them at the very beginning that they can't expect to make redundancies the day after completion or indeed to announce the deal without having gone through an information consultation exercise. So it's to work backwards from the end date and then explain to the client exactly what the steps are that need to be done in the process, but to do that as early as possible.
I'd probably say finding out what the buyer's management's plans are for the employees, because that impacts upon how long this process is going to take before you can actually complete, and also how smooth a process it's going to be, how many challenges are there going to be, and then you can manage everyone's expectations. So I think once you know the plans, that certainly helps you in terms of planning the whole deal.
Cool. And Emma?
I'd say start as soon as you can commercially in terms of preparing and starting the process, and also where possible involve the local HR team because they will understand all of the local issues and cultural differences, which can really help.
I suppose there's one more key point for anyone who's going to France to do negotiations with the works councils, and that's to remember to take your sandwiches with you.
Indeed. I think with that, we've been sent through a few questions, and I might now take the opportunity to turn to those questions. One here that we have is a question around the automatic transfer principle. So again, forgive me for looking at the screen as I read this out. We've mentioned a couple of times that there is no automatic transfer principle in certain jurisdictions, such that buyers can cherry-pick employees. And I remember we touched on an example in Australia, I think. The question is, how does that tend to impact on the employment due diligence exercise carried out in those kind of jurisdictions? So, Andrew, do you have any thoughts on that?
Yeah, I mean, it's a good question. You do, at the beginning of the transaction, you'll work out which, if you're the buyer, which are the target jurisdictions and which of them do or do not have automatic transfer principles. And then from a due diligence perspective, you'll look at what sort of terms and conditions are employees on in non-automatic jurisdictions. How many employees do you think you need if you're the buyer in the post-completion period? which employees do you think you want? Are there ones with special skills or experience? And indeed, how much is it going to cost you to take them on? So if you offer them roles, will they accept? Or are you going to have to offer them slightly more than they get now to get them to agree? Or will they go and work for one of your competitor company?
And that's why you often ask for a spreadsheet, perhaps anonymised depending on the data protection rules in a given country, but at least giving you an idea that I want person 12 because they have this skill set and this particular role. So it's trying to get down to the detail of what each person does within the organisation and then mapping on what their current terms and conditions are, because if you're going to offer them new employment contracts, you need those contracts to be sufficiently generous that the person is willing to accept the contract, but obviously not going over the top of you, trying to find the appropriate balance.
I'd say maybe there's also a bit of due diligence for the seller involved there as well, because they're going to need to know what are the purchaser's expectations and needs, because that will obviously impact on the commercial decision to sell to that individual, because the seller will be left with those people that aren't cherry-picked, as it were.
Yes, they'll have to pay all the severance payments or redundancy payments. And there's often, in those jurisdictions, you often find specific provisions being put in the sale and purchase agreement around what terms are going to be offered to certain employees, so the seller has some idea as to what position the employees will be in post-transfer.
Sure. I'm going to move on to another question. We've been asked here about pre-signing obligations and information consultation rights in that context. There's a particular question about UK consultation obligations in the context of the 2P regulations. The question in particular is, when the deal has been signed, is it possible to argue that consultation is meaningful if it's only happened moments before that signing?
If there's a period of time between signing and completion, then our view is you can do a meaningful information and consultation exercise. Obviously, if it's a simultaneous signing and completion, then that won't have happened. But often there'll be a period of time between the two, and you will take the seller will undertake an information and consultation process. And what we're finding more often is that the seller will invite the buyer to cooperate and participate in that process as well. So it may be that a representative of the buyer will come along. But no, our view is that as long as you are timetabling information and consultation, and you do listen to representations made by the representatives, whether they be employee representatives or trade unions, or indeed the employees themselves if there are neither, then we think that there are robust grounds on which to defend any assertions that you haven't informed and consulted properly.
True.
It's also important to bear in mind that a number of jurisdictions, in the UK, in a number of transactions, you may only have an information obligation rather than a consultation obligation. So consultation obligation is triggered where the employer itself is proposing measures, so changes to terms and conditions. So that in this context would be the seller proposing to make changes before the transfer. Where if the purchaser is proposing changes, then the seller has the obligation to inform the employee representatives about it, but has not got an obligation to consult. So it may be that actually, because it's not a consultation context, that you're not having to discuss whether it's meaningful or not. You're talking in the context of notification and providing information and answering questions.
Sure.
It's an interesting question, because if you compare that with the position in France and the Netherlands, those jurisdictions will say, well, it is meaningless. There should be involvement of employee representatives in one form or another before you sign, because the inference might be, well, once you've signed, are you really going to change the deal or not do it? Probably not. But at the moment, we think in the UK, certainly you can satisfy those obligations in the way that Christine has outlined between the signing and completion dates.
Sure. One further question I think we have time for is that the question here is, we referred earlier to a traffic light system of indicating more problematic different jurisdictions with criminal sanctions, and amber for civil sanctions and green for less problematic. The question posed is, where can someone look to get such a quick and easy context or ready reckoner for where the risk lies?
Sure. Well, our guide, the here we are, has a section at the back of it which has basically the traffic light table by indicating with the red, amber and green dot which of the jurisdictions we've identified from our experience would fall within each of those categories. So, and also that will help you answer any specific questions you've got on each of the jurisdictions, because I appreciate we've covered them all rather quickly during this session.
Well, I think the hope was always that we would share with you today some of our experience and our knowledge in a variety of jurisdictions gained through a practical approach to a number of jurisdictions over the years. I think it remains only for me to thank our audience, thank the panellists and each of you for answering my questions and indeed the more important questions posed by members of our audience. So thank you, the three of you, very much. Thanks again to our audience, and we hope that you can join us again for another one of our webinars in the near future. Thank you.